Alright, Travis Wayne Goodsell. Here's the objection to Order 31 and Judgment 32 in case number 220 CV00633, Travis Wayne Goodsell, plaintiff versus Corporation of the President of the Church of Jesus Christ of Latter-day Saints. The following statute is Rule 46, which allows me to object. And here's number 1. The First Amendment requires all courts to allow citizens to petition the government for a redress of grievances. The Sixth Amendment allows criminally accused to be informed of the nature and cause of the accusation. Though the plaintiff has filed a civil lawsuit, the federal courts provide a set of rules and processes and procedures. Yeah, I should put plural on that. A pro se litigant guide provides the forms for the pro se plaintiff to follow and adhere to. Your Honor has joined the illegal position that the pro se litigant guide is a violation of Rule 8 to justify the denial of the plaintiff from presenting evidence in the evidentiary hearing, which court documents have a specific form for the plaintiff to list all evidence, to have filed with the court in adherence to the Sixth Amendment to protect the defendant from false accusations and biases from compromised justices. Instead, Your Honor has joined with the other justices in showing bias in favor of the defendant to suppress the First Amendment right of the plaintiff. For Your Honor to not just grant a judgment on behalf of the defendant, but to grant with prejudice when refusing to allow the plaintiff's evidence to be presented represents conspiratorial corruption, especially when Your Honor intentionally delayed judgment for 3 months. 2. In Your Honor's Order 26, the plaintiff lodged documents. The plaintiff's lodged documents 27, 29, 30 are required to be filed by the clerk's office for the public record as ordered. As likewise, Your Honor is required to submit to the clerk's office all the plaintiff's emails to Your Honor, including to the defense counsel, and to be included with the docket for the public record. Did I put the clerks involved not needing to do this? It assumes that the clerk's office are supposed to do that. They haven't. Okay. 3. Your Honor's illegal order and judgment incited the public to cyber attacks and threats to the plaintiff's life. With one such threat was provided in the emails mentioned in number 2. One such cyberbullying threat to the plaintiff included the cyberbully's knowledge of Your Honor's order and memorandum decision 24 by quoting from it before being made available to the public and even to the plaintiff. Talked about that in an earlier video this morning. The plaintiff notices that Your Honor worked overtime that Thursday, forcing the clerks to likewise stay overtime as well. 4. Your Honors, 3-month delay allowed the defendant to join in the incitement to insurrection at the National Capitol on 6 January 2021. The plaintiff gave this court advance warning, having prior knowledge of the coup of America, the coronavirus used as a weapon upon American citizens, and of the white supremacy, sedition, terrorism, working with Russia and other hostile nations, and the criminal organization of the defendant. Your Honor's judgment on behalf of the defendant adds Your Honor to the list of conspirators with the other justices and others listed in the complaint. Note that one of the plaintiff's submitted documents, not filed by the clerks, includes a motion of recusal for Your Honor. The public must learn that Your Honor gave an order in violation of Rule 11 to protect the defendant and prevent the plaintiff's evidence from becoming public as required by law. 5. Your Honor claimed that every count of the plaintiff is incoherent and not factual. Your Honor has shared knowledge that this is a lie. Motion to recuse 18 was denied in a docket text order 24 by Your Honor as moot, as Judge Jenkins consented to the plaintiff's motion with his recusal order 20. You see the order? I asked for Judge Jenkins' recusal 18. He then complied in order 20. And then she came along in 24 to deny it. 6. The defendant not only incited Mormons to insurrection, still to this date has not shut down their organization. As the state, in conspiracy, refuses to shut down the state, as the pandemic continues into a second year at red levels, requiring a shutdown of the whole state in accordance with medical processes and procedures. The economy does not have precedence over human lives. The plaintiff has, since Your Honor's illegal judgment, submitted a terrorist threat tip to the FBI, which included the Utah FBI as compromised, informing them of the defendant's insurrection, and includes the Utah federal court justices. So we shall see if the FBI at the national level is still compromised in the sedition against America. And then dates need to be changed to the 1st, not to the 2nd. Would be cool if I could just wait until Groundhog Day. But I don't want to sit on this any longer than I have to. So as in all previous email submissions, in this case, I will have already sent it by the time you hear it. And if someone dares have a comment right after I just uploaded it, and you're quoting from this, I will know you have hacked my computer and you're listening right now. God.